conversation around the constitutional provision that provide the grounds for the removal of a Chief Justice of the Republic of Ghana. As we speak, the Chief Justice, or the suspended Chief Justice, if you like, Gertrude Tokonum, is about to face a panel of 5. And the job of that panel is to determine whether she is fit or not to continue to serve as Chief Justice of the Republic of Ghana. Now, yesterday on the program, we had the views of a former Supreme Court judge, Justice William Atukuba, and he took on even the MPP, accusing the party of hypocrisy, because according to him, the MPP benefited more in the rulings of the Supreme Court when the party was in power, and finds no reason in the party's decision to protest a constitutional provision that has been triggered for the removal or the potential removal of the Chief Justice. Now, this afternoon on the program, we are privileged, highly privileged, to have a former Speaker of the Republic, a law lecturer, former law lecturer, and I enjoy him, of course, a former political science lecturer, and I enjoy him, his retirement. Of course, Right Honorable, retired former Speaker of Parliament, Professor Aaron Mike Oquaye. Prof, you're welcome to the program.
Thank you very much.
And it's good to see you. You are looking good even in retirement. How is retirement treating you anyway?
I read and I write.
So a typical day for you is like?
Read and write, listen to music, particularly some gospels.
Do you watch football sometime?
Oh yes, yesterday I watched Arsenal.
Disappointed that they are out of the Champions.
I'm a Chelsea man. But
right.
Actually, I sympathize with Arsenal so much. They deserve to win something.
And they lost. But your team is in the Europa Conference.
Yes.
Likely to play in the final.
Oh, they are likely to win too.
Some say that Chelsea has lost itself. Chelsea should be playing in the tier, the second or the third tier European competition.
Oh, that's a bit of exaggeration. But you know, English football is so competitive that you make a little slip and you are down to the bottom.
Yeah.
But I have supported Chelsea from 1971.
Wow.
When I was a student in England. And nothing will make me stop. Except that sometimes I feel very disappointed.
But you hope that they can bounce back?
Definitely.
Okay. Let's come home and talk about the matter that is on the lips of everybody, and the fear that there is some interference in what the president is seeking to do, going to what the Constitution says, the potential removal of the Chief Justice. First, what is your reading of what is happening as far as the Article 146 is concerned and the processes taken by this administration?
A number of the things that are happening are so political that when it comes to these matters, I like to put on the hat of a constitutional student.
Right.
I study the Constitution. I am concerned about certain issues that I consider vital, particularly the trial in camera provision. You ask yourself, what is the rationale for that provision in our Constitution? Is there in black and white? What is its purpose? And if we were to give it a purposive interpretation, where shall we get to? The purpose, is it to benefit the people of Ghana as a whole, that the Chief Justice might be tried in camera? Because you see that even before you get to the in-camera provision, from the very beginning, the Constitution tells us justice belongs to the people. It emanates from the people. Justice belongs to all of us as a people. One may say that this provision could be at variance with the one that says trial must be done in camera.
In fact, it is clear in Article 1468.
Yes.
It says the entire proceedings must be held in camera.
And if that is so, that will belongs to me. The people are the owner of that issue, that process, whatever happens with regard to the Chief Justice. Why should the people be banned from being part of knowing the process going on. If the people have the right as owners of the very process of adjudication, then of course they should be able to visit the farm that is theirs. If I hire a laborer to weed my farm, I don't see how the laborer can tell me, you don't come there. I am going to weed, I'll do everything to the end, and then I'll come and take my money. Maybe he won't even want you to see what he's done and yet comes to demand his pay. Will that be reasonable? Justice is reason. So you see that the two passages may be said to contradict themselves. Because if you have provided that justice is mine, then you cannot stop me from being part, seeing, observing what is going on with regard to a thing that belongs to me. If that is so, even though it is there in black and white that the trial should be in camera,
right,
there's another black and white which makes it possible for the owner of justice to visit his farm and be there. One may also say that that provision was made to protect the person who is the subject matter of the trial.
Right.
Some people say, oh, it's such a high office and so on and so forth,
whatever has been,
that whatever happens should not be washing dirty linen in the public and so on and so forth. But first and foremost, the dirty linen has already been washed in the public.
Absolutely, by the fact that you've been accused of
exactly all manner of things.
Right.
So if it is for the benefit, that's what I'm talking about, a purposive interpretation, which the Supreme Court has seriously taken account of since this was actually first hammered by Professor Justice Dateba. It's a very, very important thing because it goes to the root of the matter. Right. It makes you understand why the provision is there at all, and for that matter, the application thereof. So it may be said that it is there for the benefit of the Chief Justice on trial. I don't want to talk anything about a particular person, whoever is the Chief Justice on trial. But as I said, the matter is already in the public realm.
It is. Indeed, people are even referencing the exact issues against her.
Exactly.
And so, the secrecy aspect is already broken.
It's broken. If that is so, then the purposive interpretation should enable you, the beneficiary thereof, to now say, I don't want a secret trial. I don't know the position of the Chief Justice. I am talking in terms of jurisprudence and analysis. I don't know. But in that case, the Chief Justice, whoever the Chief Justice is, should be in the position now to say, I don't want a private trial. I don't want 5 people to go and put me in a room and come out and say I'm guilty of all counts. I want the people of Ghana to hear what I have done and whether I am guilty or not, though so pronounced.
So basically your suggestion is that it should be the prerogative of the person facing this 5-member committee, in this case, suspended Chief Justice Gertrude Tokono, to demand that the entire process is broadcast to the hearing of the Ghanaian people.
Yes, because I'm saying, to whom does that provision inure? It's for whose benefit? You cannot do something for nothing. You cannot, and the basic rule in the law code is that you cannot put something on nothing for it to stand. And the whole concept of purposive definition is to give it meaning, to give it purpose. So I say the first purpose is the purpose of the public good, which is provided in black and white in the Constitution. It belongs to the public. It belongs to Ghanaians. If that is so, we cannot take it away from them. And because that too is also part of the Constitution. So if you put the two together, they don't really rhyme. And for that matter, one must go. And for that matter, the one that must go is the secret trial provision. That's what I'm saying. If you come to the other leg, that is, it is a human right of the a person on trial, that the dirty linen should not be played in the public. Therefore, let it be done in secret.
Right.
Then the person turns around and says, I don't want that right. I will prefer that whatever you are going to do it publicly, so that my church members may know whether I'm guilty or not. I don't want a secret trial. Furthermore, my good gentleman, the whole concept of trial in secret is a very serious matter.
Why?
Because it goes against the very foundation of justice.
Justice must be seen to be done.
Exactly. Justice must be done. Not only that, it must be seen. In fact, some people even add manifest. It must be manifestly be seen to be done. To be seen by who? That's a foundation of our legal system. The British, even though they don't have a constitution, so far as matters of open trial and trial by the ordinary courts of the land, so far as this principle is concerned, they reduce this in the Magna Carta.
Right.
As for this matter, let us reduce it to writing, because it goes to the foundation of our society. We all know the history of this country. The public tribunals, the People's Court, how people were blindfolded, pushed into a room, dark room, and could not see their accusers nor their adjudicators. We have decried it, and we say we don't want that kind of thing anymore. Maybe it's an unfortunate relic of the bad old times, and people must seriously re-examine it again. And that is why we can give a purposive interpretation and say it is not congruous with the provision that justice belongs to us. It belongs to us, and we all want to, if we may say colloquial English, see some.
Okay.
But
I'm trying to understand the wisdom behind the framers of the Constitution, as far as, I mean, the provision 146(8) is concerned. I'm trying to understand perhaps what motivated them to have come to such a conclusion. And you say that sometimes it is to protect the office of that particular person. Even in matters relating to national security, after they say because of the sensitive nature of the matter is in question, the trial must be held in camera. So if the person in question...
Even a part of the trial must be held in camera. That is when they are going to discuss maybe some security documents. But as for the trial per se, a person must ordinarily be tried by the ordinary courts of the land. Remember the Chatu Chikata case?
Right.
He made a very important pronouncement on human rights. He said, I want to be tried by the ordinary courts of the land, not a special court established for me. I agreed with him 100%. That being the jurist that he is, he appreciated the notion of the ordinary courts of the land. I want to go to the High Court. Try me before any court. But don't establish a special court for the trial of me only. How can I trust
the process?
The process.
Right. So in this case, because this is the first time a sitting Chief Justice is being taken through this process, and the implications are quite clear. Should she request this open trial, that is if she so wish, who must she make the request to? Is it to the committee, or somebody must go to court and get a court to pronounce on clause 8 in Article 146?
I believe the easiest way will be for the Supreme Court, the full court of the Supreme Court, to sit on this matter and pronounce on that, full arguments held. Because you see, and that is the thing that I tell you honestly, whether it's one party or another party, I don't like in this republic. I want us to establish principles, and we'll go by them. Let us revisit even this whole procedure.
Exactly, I was coming to the very start.
Okay, as provided by law. Any one Ghanaian makes a complaint.
Right.
He takes this to the presidency. Then the president does some consultation with the Council of State. It comes back. Then the president has the power by law. And when I say president, I don't mean
the current one.
President.
The office.
I've consistently said I don't like it to be said that I'm talking about President A or President B. The person who is president, man or woman, then constitutes a panel. 5 people. 2 Supreme Court judges. And of course, I don't believe there's any Chief Justice in Ghana who did not have some problem or the other by way of preference, whatever, with some 2-3 Supreme Court judges.
We'll come to that in the course of this.
Okay. It's not possible. Then you pick any 2 Supreme Court judges. Then you also can pick 3 other civilians, not judges, not lawyers, and so on, that you think can do justice or go into the matter. Then the 3 go and sit. The 5 go and sit. Judgment is by majority. So the 2 Supreme Court judges may say yes, and the 3 civilians, ordinary people,
they are not lawyers.
No. That 3 must hold.
Right.
Because it's a majority. And then thereafter, there is no appeal.
The matter is closed.
The matter is closed. I mean, my brother, if it were you, we would like to appear before such a court. It's ridiculous.
Yes.
I don't blame anybody. It's there in our law.
So therefore,
let me just finish this. Why even is it that Ghanaians have watched this being their law for so long? And some people who today are criticizing the system said nothing. They did not speak about this. When I was mounting the IEA Constitutional Review series,
right,
I wrote on all these things. I said, oh, there is my paper already. It is published in my contribution to the University of Ghana alumni lecture on the Jubilee, which I gave.
Right. At
the Jubilee time, which I gave in the Great Hall in Legon. 10 years ago, I had written on this, and so on and so forth. Why do we allow such things to happen? And then we cry foul when it appears as if a particular best person is going to suffer. And this is what personally I don't like. Let us talk by the principle of it. What is good for the goose, good for the gander, everybody. That is important.
Let me take you back to the possible outcome. And you made reference to a 5-member committee, the 2, for example, the 2 lawyers may take a position, and then the 3 other individuals may take a different position. And then that will constitute finality to the matter. And I'm wondering whether these individuals, for example, if they are influenced by some other affiliation rather than the facts presented to them, that affiliation can sway them to take certain positions. And it will lead to the exit of the Chief Justice.
Sure. That is what it means. It means, therefore, that once the president decides you should go, you're on your way out. You know, I don't know why very often we don't analytically record historical events. There was a fine judge in the Supreme Court, Justice Amoasechi. The right to demonstrate in some of the early Supreme Court cases, he expounded the law.
Right.
And for that matter, enhanced the human rights of Ghanaians. But some people didn't like him at that time. At one time, there was an attempt to get him of him in this way. And then the good old, well-established lawyer and judge, when they were in the process of going to do empanelment and so on and so forth, he read between the lines and retired from the judiciary.
But Prof, I'm curious to know, I mean, are you happy with how the process has been handled so far, from when the petition was presented to the CJ even requesting the president to give her a copy of the petition, and then the subsequent exposure in the media about the content of the petition, even the CJ's response to the petition?
I've not followed that aspect well. Because I've not read the fullness of the report. I've seen what I may call excerpts in the media. That also goes to factual issues before the court. I mean, it's not a judicial panel. Therefore, I personally would not like to go there because it can be said that it is prejudicial to the matter before that tribunal of competent jurisdiction. What I am very much keen upon is exactly the issue that I've discussed with you. And it must be resolved as a preliminary issue. Because if you were to put me in such a trial, I wouldn't go. And I wouldn't plead. I wouldn't say anything. You can do whatever you like. Because I would like the world to hear. And I bow out according to what is being heard. Putting a person in a room, coming out thereafter to say what occurred there. When in this country we have so much controversy over matters that even all of us are seeing and hearing. You will be surprised at all the interpretation.
You were saying that if you were in the shoes of Gertrude Tokon, you would not appear before this committee.
I say, if it is going to be secret trial, I won't appear. You can do whatever you want to do.
Because you don't trust the process?
No, it's not a matter. You see, I wouldn't want to single out any particular event. Okay. But as a matter of general principle, I am telling you, no Ghanaian would like to go through that kind of process. I mean, it is a very, very important principle, and it's a human rights issue. And that's why I say that human right of the person who is the victim and accused in this case must be seriously examined. Give her that fair and open trial. And then we can all see. I'm telling you honestly, if a disciplinary action is given against a messenger in the judiciary, you know, he or she will be entitled to take the matter to the High Court when a decision is held against that person. And the Constitution says the person is also entitled to appeal to the Court of Appeal. And then you can take it to the Supreme Court. And furthermore, to the review committee of the Supreme Court.
Right.
But in this particular case, the person who is being tried in secret cannot even appeal. So let the world see it once and for all. It is a very, very important jurisprudential and human rights issue. Nobody wants a star chamber court. Nobody wants secret trial. Even in our traditional system, which is guaranteed by this Constitution, our traditional law, customary law, and so on. That customary law, whether the case is a FISEM, that is a small family case,
right,
or it is a MIND-SEM, that is a proper national or village or town matter, the trial must be held in public. And on certain days specifically set, and people can come and listen. Some people go to the court just to pass time. Do you know that? To go and hear cases. A person is entitled to hear cases in court.
In this case, it's even unclear whether the committee has started work. It's unclear whether the suspended CJ has appeared before them. But it's not too late to make changes.
I think it shouldn't be too late. And whatever has been done up to this stage, the Supreme Court should be able to go into this matter and declare whatever has happened so far null and void, and then start open trial. Because a Ghanaian's human rights are at stake. And it's very, very important. And that is why, look, there are many people who, if this is how a Chief Justice can be removed, will tell you, I'm not interested in the post.
In the post?
Oh, no.
Prof, indulge me.
It will happen.
Indulge me. Let's spend some time on this matter so that the understanding is clear.
If this is how a judge can be, of the Supreme Court, can be cocooned into some room, 5 people, nobody can see some, nobody can hear some, and then after somebody will come and tell you the verdict. There are many people I respect strongly in the bar, at the bar, and at the judiciary who will say no.
This is a very important point.
It's an important point.
You are making.
We will be destroying the judiciary if you go this pathway.
And
I will come and be a Chief Justice. What for? I say 5 people chosen by 1 man. I'm not talking about even the person who chose. 1 person chooses 5 people of his choice, and then they can come out with any judgment which is done. The process takes place in darkness. I mean, in the closed room. Oh, no. There are many people who want to be judges.
And so you say that the court must declare whatever has happened null and void.
I say, I don't know even. But it is possible. I'm not saying what must be done. I'm not clothed with that power or authority.
You are suggesting that the court
But it is possible that the Supreme Court, having by the full bench, had this matter on the purposive factor and why a person must be tried in camera, and whether it is consistent with other human rights provisions, and whether it is consistent with the basic formulation which precedes the judiciary, that justice belongs to the people and it is administered in their name and on their behalf. If the thing is mine and you are administering it on my behalf, I should be able to come and see some.
But how would this work when whatever is happening is a constitutional, steps enshrined in the 1992 Constitution, where the president is only a conveyor belt in this matter and is asking the process to flow? The court has no role whatsoever. So is it a tax, for example, you are prepared to take in the court?
The power
in terms of uplifting the human rights of the individual, in terms of opening the process up to ensure fairness and transparency.
It can be done. That is why the Supreme Court is there, to interpret the Constitution. Because I've given you parts of the Constitution which say otherwise. I've given you the jurisprudential history of secret courts, which we don't want. In the United States, and this is a law that everybody who's been to law school knows, Marbury against Madison, a fundamental issue which changed the face of the law and gave the judiciary the power to even quash laws made by Congress in Parliament. It was not specifically provided for in the Constitution. But the judiciary and its functions, which had been given it, the court, led by Chief Justice Marshall, came to the conclusion that, and the logical conclusion, that if we are going to go by the rule of law as so provided by our Constitution, then the law must take precedence over everything. And everybody, including the legislature in America, the president in America, he can declare what you have done ultra vires, beyond law, and for that matter, make it null and void. This is the purposive interpretation of a Supreme Court. And that is very, very important, because it tells you, marry all the principles. Don't just look at one provision and then say, hey, I've got something to run away with. That is, it must be done in secret. How do you reconcile it with the basic principles underlined in the Constitution? It is something that the Supreme Court must look at.
So under the circumstances, under the current circumstances, you say that if these steps are not taken, if a person, under the circumstances, if these steps are not taken, a person appear before a committee whose hearing is shrouded in secrecy, then you're already gone. Well, more especially when the person who is facilitating this is responsible for selecting who should hear your case.
It is serious. And, you know, there are so many political angles which I wouldn't want to tread into. I want to restrict myself to the obvious. Let everybody see clearly that as for this provision, that one man can choose 5 people, and then they will go and sit in a room alone with the so-called accused and come out with their decision on the person, is not fair.
But somebody must bring the Supreme Court, somebody must bring this to the attention of the court. Is this something that you're prepared to do?
I don't see why, in fact, maybe nobody has taken the matter to court still. Some serious Ghanaian must take this to the Supreme Court. And it is an interpretation that must be made by that court. And let them all, in their conscience, examine whether, if it were me, would I like myself to be subjected to this? Because, you know, if you don't take care, a very dangerous precedent will be set. And I tell you, it will be... I say the Chief Justice can be dismissed more easily than a messenger.
Are we sitting on a time bomb? As far as this matter is concerned,
time bomb is too strong an expression. But
this is an arm of government, supposed to be independent, being removed by another arm, and there's no remedy whatsoever.
And that is why I ask for a constitutional reform. And this thing is in black and white in my recommendations. My article at the IEA, published some 15 years ago, titled Countervailing Authority, it is there. My alumni address at the University of Ghana, it is there. We must change these things.
I will come to the attempts to review the Constitution, but because we are in the court, let me ask you this. What, in your view, should be sufficient enough to establish a prima facie case against a sitting CJ, since Article 146 doesn't give us that clarity?
You see, there is a case going on. We may say the matter in that regard is sub judice. I wouldn't want, and something has been said to have a prima facie case already. I wouldn't want to say anything that will prejudice that. I want to take myself out of the controversial areas.
But you say that it is too easy as in the present circumstances to remove
a Chief Justice. It is too easy.
And some say the threshold what is constituting the case against her, the threshold is so low.
I wouldn't say what is constituting the case actually. The threshold is low because I don't know all the charges. I don't want to comment on that. I don't know.
The matters that are already in the public domain, you probably following.
Those things are supposed to be allegations.
These are being trumpeted by very senior government officials, and they say that they are even telling us the response of the Chief Justice to the extent that the communication officer of the NDC says that even when the matter was brought before the Council of State, out of the 31 membership, 30 voted in favor for the Chief Justice.
My dear friend, the person who said all this, if it is true, bow his head in shame. You know why? No. The Council of State was not established to be brought into the public light like this. If the Council of State have decided upon a matter in a certain way, it is not for you to come and tell the public what the Council of State, who are advisors to the President, said to the President. I don't know how any public officer will go on this tangent. And it's unfortunate. You mean to say that person really, I have not heard it. But if it is really true that an official went and gave the details of the happenings at the Council of State,
right,
then he has really betrayed the system. It's not right.
It's not right.
It's not right. And that is why I don't want to go into those they say areas. I'm talking about the principles which will continue to exist unless we re-examine ourselves.
Yeah, I just want to add this to it. And according to this same government appointee, out of 31, 30 voted that there is a case for the suspended CJ to one side. The only person who did not vote, and this person we are told abstained, and this person is the former Chief Justice of Yakubu. Now, at the IEA program relating to the process to review the Constitution, the former CJ says, and I quote, "The current constitutional processes outlined in Article 146 of 1992 Constitution for the suspension and removal of the CJ is unfair and must be reviewed."
You know what? I haven't heard what Justice Akufu and her abstention or whatever. And I don't want to go into those areas. Who knows, maybe it's not true.
But the unfairness she raises ties in with the proposal you are making today.
Well,
maybe.
I don't know what are the parameters of that unfairness. I also know that the good lady has said that she was misquoted. Okay. And you see, that is why I want to take myself out of any of those, what I may call political, or I'm talking actually about the little law and jurisprudence that I know, and the sense of justice that I have, that this matter, there's no even one magistrate who would like that to be done to him or her. How it is, to me, it is ridiculous.
Then our Constitution...
But you see, it's because people had not seriously analyzed it.
Because this is the first time.
The independence of the judiciary,
yes.
Independence of the judiciary, they are joking.
There's no independence.
It doesn't exist. I mean, I say, you cannot do this to even a clerk in your office. Because you see, he has a right to take you to court. And when he takes you to the High Court, it will go to the Court of Appeal and then to the Supreme Court. And to the Supreme Court review. But this one, no.
No. There's no avenue for remedy.
And some of us have written. And you know one unfortunate thing. Many senior people who could also have helped in this process when I was leading this constitutional reform, because they were in position ruling, they didn't see the need to come to the aid of actual reform until something bites somewhere else, and then they see the need. We must just, look at all the conceptualizations we have learned in the study of the law and the practice of the law, and reach our Constitution for the benefit of posterity. And not that when any particular one case comes, then we start jumping or not jumping according to the side that we support. It will help the Republic.
As a lawyer yourself, and a seasoned one for that matter, let me pick your brains on some matters that happen in court relating to the same issue. So the Member of Parliament for Ota, for Vincent Asafua, went to court, his lawyer, the former Attorney General, Godfrey Adame, and they sought to challenge the process and made an application that the entire process should be halted because they didn't understand why it took the president so long to, update the Chief Justice on the matters against her. And so, in their view, the time lapse was not the best. The court yesterday in this ruling came to the determination that there was no merit and ruled against that particular application, 3-2. They were seeking to injunct the entire process. What's your take on that?
When a lawyer wants to comment on a case, he must have the full proceedings, the arguments made for and against. I would rather not comment on that because I'm not well seized
with the matter. But is it also right that in this same case, the suspended Chief Justice had empaneled, some judges to sit on the matter, and then because of a suspension, the senior-most person on the bench assumed the role of acting CJ, and he also decided to reform the panel, included 3 other individuals and took 3 other individuals. Now, the MPP's position is that those additions voted against the injunction application. That for them doesn't augur well. they think that there's some other considerations going. Are these comments healthy as far as the Supreme Court and
I have made recommendations regarding how judges are even appointed.
Educate us on that.
I've made recommendations as to even how the Chief Justice is. Almost invariably, every Chief Justice appointed in this country during the Fourth Republic has brought some controversy as to political entanglement. In Kenya, for example, the Chief Justice is elected or chosen by all the members of the Supreme Court themselves. So you cannot pick and choose as a politician. The appointment of Supreme Court judges, some people say we must cap the number, and that we simply pollute the court with political appointees so that now we don't know how many we need. They say even the United States of America has got a limited number of judges. And then they want that to happen to the situation in Ghana. It's a very good idea, because even in the US of A, packing the courts has been a long issue for so long. It is actually a real issue. And it's not good for us.
It's not only a Ghana problem.
It's not only a Ghana problem. We're packing the courts. And that is why there must be limitations. But if there should be limitations, certain things too also must be done. The Court of Appeal should be made the essential court of the last appeal, and even maybe giving a right of review by way of 5 appeal court judges. That takes the burden off the Supreme Court in ordinary cases, because now it will surprise you. Every little land case, every little civil matter, and so on and so forth, also land in the Court of Appeal, because this very constitution gives the Ghanaian right of appeal to the Supreme Court. America is not like that. So you see, you cannot just make a demand without making a change, because that is not what happens in America. Therefore, we need the constitutional review to seriously analyze these matters. Otherwise, I may even say we are joking in this country for our democracy.
That's very, but then also, I mean, does it sadden you that now it looks like every decision that comes from the court is interpreted with political lens?
That is saddening. It's saddening. And it is the beginning of a very serious end if we don't take care. Some politicians have warned, you go on with your appointment. When we come, those people should just pack and go, because they will be sacked. Some people have said it. I feel sad about such things, that Ghana should come to that level. Because I'm saying it's easier to sack the Chief Justice than a messenger in the judiciary.
I mean, yesterday on this same program that we are on, I had the privilege of hosting the respected former Supreme Court Judge, William Atukuba. He was not charitable with his words at all. I mean, to the effect that in the last administration, the last 8 years, the MPP had a lot of unanimous decisions from the Supreme Court. Questions 8. Is it right? Is it fair criticism?
No. I have not made an analysis of all those judgments. Therefore, I'm not in the position to judge Justice Atubuga. But if a man who had been acting Chief Justice before is of that opinion at all, then the country must examine ourselves.
Remember that when the MPP was in power, Mr. Kandapa, then National Security Minister, as he was then, even made proposal that sometime the courts must balance their rulings in the interest of national security.
I think that statement was unfortunate, maybe because he's not a lawyer. But balance in what way? I mean, if in order that the people will trust us, we should say, oh, the way we are 5, okay, 1, 2, 3, give decision for them, and you two give against so that they will say that we are balanced. We don't do that in court.
And that for me is even more dangerous, isn't it?
Oh yes, very, very, very dangerous. And you know, in this country, judges give decisions and they bring their reasons far, far later. It must stop. A judge should stand by what he thinks. And in fact, it is the rule that every Supreme Court judge must write his or her judgment in full. So this kind of one person speaking for the court and so on and so forth is a lazy approach, and it better be stopped. Because a judge must stand by his or her judgments. In Parliament at one time, I wanted a situation whereby all votes to be recorded, as that's in the United States Senate.
To reflect how MPs voted.
To reflect how MPs vote. You remember, when Obama was contesting for the presidency, his record on all these things came out. In fact, he himself stood by his record, and it became a credit to him because it showed he had done a lot of work and had conceptualized effectively in the Congress, in the Senate. Now, good. At one time when President Mahama and ex-President Akufo-Addo were contesting, they had both been members of Parliament before.
Right.
And they had been successful and long-time members of Parliament. Well-respected gentlemen. But there was no record on how they voted on women's rights, how they voted on environment.
To actually show their stance on these
matters. To show
matters.
their stance. And these are some of the things that make our politics vituperative. You see, if you don't talk on issues, then you can't talk on insults.
So therefore, it's not out of place that, for example, in the last regime, most of the cases that went before the Supreme Court, the court came with a unanimous decision.
Yeah, it's not out of place, actually, technically speaking. But maybe they know other undertones that I don't know. You know, in the United States, any time the Supreme Court sits, it sits with the full members. Because I am particularly not happy about the empaneling powers of the Chief Justice.
You're not happy with it?
No. I've written on it.
That the Chief Justice shouldn't be the one to empanel courts.
There must be a system of a detached empanelment. In other words, a machine, like a lottery. You have to distribute the cases among the judges. Human discretion is a very dangerous thing.
Of course. Of course.
Human discretion. So let the cases be distributed by a lottery system so that there will be detachment, so that there will be confidence. But in America, when the Supreme Court is sitting, it sits in full. And that is why I say, let the Court of Appeal be the final court of appeal for regular cases, except in exceptional cases where special leave will be given. Then you don't worry the Supreme Court unduly with all manner of small land cases. You can even go to the Court of Appeal on review. We can make a provision for that, you know, so as to leave the Supreme Court like it is in America to do those cases. And when they sit in full. Because the empanelment gives the Chief Justice, whoever it may be at that time, the power to choose who will sit and who will not sit. And many judges have not been happy with this.
Because
since
clearly,
time immemorial.
Because clearly, if I'm a Chief Justice and I have issues with some of the members, it's possible I may sideline them in terms of them sitting on specific cases.
Yes, it can happen.
But is it also possible that the manner in which one was nominated and appointed to the Supreme Court could have influence on the way they do their things politically?
That is also possible. And that is why we must bring tight rules. Let me tell you one thing. The choice of a Chief Justice should not be a mere matter of seniority. No. It is not so in America. It is not so in UK that the most senior judge on the association becomes it. No. Because there are a lot of things that have to do with a chief justice, not mere seniority. A person may be the most senior, but he may not be the most instructive. Honestly, in America, I've just talked to you about Marbury and Madison.
Right.
And then another case in that same manner was McCulloch against Maryland. These were powerful cases. Who presided over all of them? Chief Justice Marshall. And the whole of America and all the English tradition regard him as the #1 judge ever known. Chief Justice Marshall. Later on, men like Lenin came on. But Chief Justice Marshall did wonderful work on constitutional law. How did he come to be Chief Justice? He was a jurist and a professor. Another jurist and professor, not even a judge yet, formerly in the Supreme Court yet. There was a predecessor who was nominated by the president. Congress, the committee, the judicial committee, examined him for 2 days. And they said the man didn't have vision. Therefore, they did not appoint him, recommend him. Yes. And he was a very brilliant lawyer. And then the president nominated Marshall. They spent 1 day with him, not even a full day. And they said Marshall had vision. And they nominated him, and it was approved by the legislature. And you see what he did? I'm just trying to say, we must appoint people with vision
and competence.
Privately, let me tell you, one man I feel sorry didn't become Chief Justice is Justice Brobe. Maybe circumstances didn't favor him.
An uncle of mine.
Really? I mean, I personally will testify his integrity, his honesty, his knowledge of the law. He being a student of the law, perpetual student of the law, studying and delivering. That, to me, is a Chief Justice material. So, it's not always seniority. People may say so, but I wouldn't. And I can give you several reasons, including the case I've just given you, for example. It means, therefore, that sometimes you've got to go beyond that. And those people who approve of them, they must be serious. Like the U.S. Senate was serious, is that not so? But sometimes we don't even know what we want. We say vetting committee by way of a committee for prior approval. We know that it's not done in detail.
No.
I mean, everybody knows this. In America, the committee is the committee to which the minister is going to belong. In other words, if you are going to Minister for Agriculture, that they call it Secretary for Agriculture, you are going to be examined by what? The Agriculture Committee. They have the record.
In the new Standing Orders of Parliament, they co-opted members from specific committees related to the subject.
The thing really must be done by the committee.
Okay. Let me ask two quick questions on the Supreme Court that we can move into other matters. So yesterday, for example, Justice Atuguba's opinion on appointment to the Supreme Court, as he in the last appointment that was done with President Mahama 2 weeks ago, seven new names to the Supreme Court. He said he wanted to see a mix of people even from the academia, from the bar, because you are just going there to deal with constitutional matters, not necessarily because you've been a lawyer of so years, just practicing at the High Court, and then by extension you are appointed to Superior Court. He wanted to see a mix of people from the academia, from the bar, to be such people worthy to be at the Supreme Court. What you make of this?
That is, and it's in line with what I've just told you. Chief Justice Marshall came from outside. Professor Dateba came from outside. Professor Nia Shikote came from outside. Professor Bensa Bunsu came from outside. I mean, you just have to enter academia and you know the record of this lady and gentlemen. Men and women of knowledge and integrity. Bring them in at that level and they contribute marvelously.
Another issue on the Supreme Court before we move to other subjects. Your party, the MPP, they poured on the streets of Accra on Monday, demanding President to reinstate the suspended Chief Justice. They described the President as a tyrant, that the process is undemocratic, and it is meant to weaken an arm of government and have governmental control over the judiciary and all that. I think they were right to have done so. Some say that they
you like the politics too much.
It is part of the system we are in.
we must depoliticize some of our issues. But you see, when people smell politicization, they also cough politicization. And that is, I believe, what is now the problem of our country. When you get up in the morning, you take chairs, and then it's MPP, NDC, MPP. We better stop. We better stop. We need to build a nation. We need to build a nation. And that is why we must seriously examine this constitution. A constitution which allows that when the whole of parliament even passes a vote of no confidence in a minister, the president may or may not sack the minister. What do you take parliament for? And it is there in black and white. And every day we just dance around issues and we don't change certain things.
Too much power is in the hands of one person.
When in our constitution, a minister needs prior approval before he assumes office. But a minister can sign a mining agreement with a foreign company according to what he thinks is the best without approval of parliament, and yet it is working. Why? Because instead of making that constitutional provision subject to prior approval, we have made it subject to ratification. It means ratification comes after the event.
Yes.
Therefore, 1 month, no ratification. 1 year, no ratification. When will the ratification come? And we know it is wrong, and we keep on doing it. I personally feel so strongly about such things. You must not do this to even class 1 boys and girls. But we are doing it to our people. We are doing it to our nation. It might be matter, and I told the Constitutional Committee when they met me at the IEA, we have to tighten the screws because our people cannot do a Mabry and Madison. He laughed because he understood the principle in Mabry and Madison.
This is a pause here on Joy News. My guest this afternoon, of course, is the respected former Speaker of Ghana's Parliament, Professor Mike Oquaye. And of course, we've been talking about the Superior Court, his own opinion on the matters, how things can be reformed, and all those issues. We'll take a short break. When we return, I will be winding up with him on some other matters, maybe some recommendations that he's made to the Professor H. Kwesi Prempeh's committee that is seeking input from Ghanaians in an overall agenda to reform our constitution, plus some national, like they say in Parliament, matters of national interest. We'll look into that when we return from the short break. Welcome back. This is The Pause. Of course, my name is Elton Robe, and of course, we are still here with the former Speaker of Ghana's Parliament, Professor Mike Oquaye. Is that the arrangement, the proper arrangement?
Yes, Aaron came before Michael.
Okay.
Aaron is what my father gave me.
Okay.
I added Michael later.
You added it yourself?
Yes.
Why?
Oh, well, I wanted to take a second name.
So, you met Professor Kwesi Prempeh and his team. We've heard a lot of recommendations. This morning, for example, Atukuba again says that President Han must be taken out from the appointment of, for example, the Chief Justice, the Chairperson of the Electoral Commission, NCCE, SHRAJ, and all those issues. I'm wondering your own recommendations that you are making to this exercise.
Thank you very much. On that, I will agree with him. One thing we can really do with regard to many of our institutions, including Planning Commission, etc., Minerals Commission, is the board must be constituted by what I call institutional representation. and their tenure must not coincide with that of the president. If you give them 6 years, and they'll be nominated by who? Institution of Engineers,
Right.
Association of Planners, the universities, people who have the track record in those areas. And once more, I don't talk about any particular president.
Of course.
But why should a president suddenly be the expert who chooses members of the medical council, medical whatever board? So that what?
University councils.
University council.
Even the National Peace Council.
Why? The National Council should be men and women who have a neutral background, who can be trusted all sides of the political divide. And they are chosen by one side of the political divide. In fact, this constitution lacks so many things.
We continue to keep the Council of State, for example.
The Council of State, when I visited, myself and my team visited President Kufuor, and I've given them our report on that visit, he decried the nature and composition of the Council of State as it is today.
President Kufuor.
Yes, because he feels it does not fulfill the initial concept of a Council of State, as was perceived first in 1969, copied in 1979, and again in 1992. Let me tell you this. Every chief in Ghana, every part, north, south, east, west, has a Council of State,
Right.
Council of Elders. They are not chosen by the chief. In fact, before the chief comes, they are.
They're already there.
they are there. And they are men and women, whatever, of traditional power themselves. They are what we call the heads of the lineages, as Busia described in his book on chieftaincy. They too have authority and power. And they come there by that authority and power. So no chief chooses his elders.
No, you don't choose people to advise.
But here, we being Ghanaians and knowing very well what our custom is, we give the president power to elect many, to appoint many people of the council. So that what? Because if he wants advisors that he will appoint, then of course he has got a special advisor. Advisors, is that not true?
There's so many around him.
Exactly. So he's got them already. And yet we pollute the Council of State with his nominees again. Why do we do this to ourselves?
More instructively, where the advice is not even binding.
Yes. Why? So what do they really do? Fine men and women, of course, I can see today on the council. Men and women of achievement.
There's a former speaker, who is leading the current council.
Yes.
So should there be reform, or we should scrap it completely?
Well, I'm not a radical, so I don't talk about scrapping. But once more, my conceptualization is institutional representation. We have got the Catholic Bishops' Conference. We've got the Christian Council. We've got the Ahmadiyas. We have got the Muslim Council. We have got the TUC. We've got the Students Representative Council.
Yeah, there's a National Union of Ghana students.
NUCS, everything. Why don't we have institutional higher body? And it will be akin to the Privy Council in the UK. Because they are people of authority, not deriving the authority from the president, but they derive the authority from their own constituents.
Right.
So if you are UTAG representative or the GMA, Ghana Medical Association representative, you know who you belong to, is that also?
Right.
So you come there and your tenure is not coterminous with that of the president. So you come there with a certain neutral mind and authority from the word go. But as for appointees, the moment a person In fact, the moment you become somebody's appointee, either morally or whatever, you owe him or her some obligation.
Of course, of course. What about the selection of ministers from Parliament?
That is also one area that I've been very, very strong on. I've said this for over 20 years and written on them. They are there. From the IEA, in books in Legon, and so on and so forth, they are there. They talk about Britain. The British system, I say, can be easily placed on autopilot and Britain will go on.
Yeah, because it's a monarchy.
And the system is well established. You can leave it there and let it just move. It's not so here. Ministers must be ministers and MPs must be MPs. MPs, instead of concentrating, I've been one before, both a minister and an MP.
Right.
You are not interested in catching the eye of the speaker debating in parliament. You are more interested in catching the eye of the president.
To be made a minister.
To be made a minister.
Parliament is weakening even from the onset.
From the word go, referees whisper, the executive has won the race. Now, when you are there to check Parliament to check the executive as a house of accountability, and you are also part of that executive, is it not contradictory?
But there's even conflict there.
There's a conflict of interest. And it makes Parliament actually weak. And mind you, it even affects the sitting position. No minister goes to sit at the back.
No. Whether you are a first timer or not.
Whether you are a first timer or not. But that is not the way of the legislature. You must also grow in the Senate and become a senior senator. Senior senator per se. So I say that for the sake of accountability at least, we must have a dichotomy.
So we pride ourselves as having separation of powers, but in reality, as far as the Constitution is concerned, it's a joke.
Oh yes, because the executive has everything. Even when you come to district assemblies, the executive has all the, whoever is the president has all the power. Appointing the MC, appointing this and that, nominating 1/3 of the members of parliament, government appointee. Who is the government at all? As far as we are close, what is this? Government appointee 1/3. We have not even given that 1/3 to women, so that the women will compete among themselves for that 1/3, so that it become a breeding ground for women politicians in the future. We don't think about the rights of the women, but we think of the rights of the president to own everything. So much so that because President Rollins didn't want President Liman to be on his Council of State, he made sure that that provision that was in 1969 and 1979 was removed in 1992, so that a former head of state who is today not a member of the Council of State, just because for Liman, I won't have him here by one man. What kind of constitution that has got this selectivity on idiosyncratic grounds?
Well, let me ask you a question. Let me pick a man on this. Is it possible that a sitting president can initiate moves at the Supreme Court to have a third term without recourse to a national referendum? Is it possible?
No, it's not possible. So far as I'm concerned, and by the letter of the law, you are allowed only 2 terms. Are you going to have a constitutional amendment?
The Supreme Court can say that a 2-term means continuous 2-term, and for that reason.
No. But the Constitution doesn't say continuous. Where does the word continuous then come from?
It's not possible at all.
No, it's not possible. So far as our law is concerned, and you see, for the sake of political stability, for the sake of respecting the law, for the sake of protecting continuity and predictability, the law must be predictable.
Right.
The law must be continuous. Because if the law can be changed ad hoc midstream to suit individuals, like I was just telling you about, President Ronnie says he doesn't like Liman. Therefore, we change the law. Okay? Then one president says, I want a third term. Therefore, we start to change the law. We destroy the republic.
But this review is long overdue as far as you are concerned.
It's, in fact,
too many defenses
manifestly so. It's only when we get trouble that we remember it a bit, and then we. But please, if you can remove the Chief Justice anytime in this manner, there's nothing like the rule of law.
All right, we are concluding. Few, like MPs, who say matters of public interest. We are still fighting Galamsey. The last time we spoke here. We had serious issues with it. We are still, we still not won the war.